Good evening and welcome to this session of the live coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. And so it's really nice to have this session again. Let me greet you all well. And today we are going to go for the last leg of our journey in learning about meeting management and administration. So we have a lot of people here who have sort of greeted. Yeah, good. And excellent. I greet you all. And I'm not trying to name everybody because a lot of people will be coming in. It's good. So today we are going to continue with the management and administration. And one more thing, for those of you who will be asking me when I will be uploading these notes, 100% tomorrow it will be uploaded. 100% tomorrow it will be uploaded. These notes completely will be uploaded tomorrow, right? Now, so till the last class, we saw the rules relating to the procedure for how meetings are to be conducted. So basically, we saw what are the various types of meetings, AGM, EGM, etc., board meetings. Then we saw how the meetings are to be conducted. And so we spoke about notice, we spoke about quorum, proxy, polling, chairman, all that, business, types of resolutions. Then we spoke about the special notice, etc., etc. Then we moved on to minutes. Means after the meeting is over, we have to maintain what is known as minutes. How to maintain that, etc., etc. Now, we are going to the last procedural aspect. In fact, let me out the outset warn you that this is going to be a little boring. In the sense, much of it is going to be pure theory. Again, not very important from the exam point of view. Wherever it is important, I will tell you. Otherwise, it's pure theory, and it is like that. Okay, so good. So some of you are giving your greetings in my mother tongue script, Rituraj Honmane. Thank you, sir, for that. And others also. Good. So Manish Kumar wants to know, in case of any punishment put on company, isn't it the shareholders who ultimately indirectly pay for it? You are absolutely correct. Your question is well worded, Mr. Manish Kumar. That is why I like it. You are absolutely correct. No shareholder is personally liable, but indirectly it is the company's money that is lost. Absolutely correct. So in some cases, that is why you will find only the officer will be liable. But in most cases, as you rightly point out, company is also becoming liable. Of course, you are absolutely correct. That seems to be a lacuna there, right? Because who is ultimately responsible for the decision? It is the director. But the directors are not paying it from their pocket. But having said that, the company can always enter into a contract with the MD or directors that in case there is any penalty, etc., paid because of their negligence, then they have to personally compensate the company. You can do that. Nobody can prevent you from getting the amount reimbursed from the director. In fact, many multinational companies, when they hire the CEO and other directors, they insist on that clause. They say indemnity clause. They say because of my negligence or my not being aware of such a provision, then that will be controlled by then I will be liable to pay to the company, or better word is indemnify. Maybe now you are aware of the word indemnify. So indemnify means compensate the company for any loss. So that is the best way. So Mansiji, thank you for those nice words. And well, I don't know, but best I don't know. One of the best, maybe you can say. Okay, not the best possibly. No, one of the best is always. They're already good teachers. So as I become 58 years old, I see so many youngsters becoming teachers, and I'm feeling very proud and happy. Some of them are my students also, and I feel very happy when I see these youngsters teaching, and including one of the teachers who's teaching is my own daughter, who completed her company secretary. She went to Coimbatore, and she got married and settled on there. And then she's not wanting to be idle in the evenings. She takes classes at the Institute of Company Secretaries there, and somewhat popular teacher there, but not, I mean, that's what I'm saying. Better than me, I would say. She's too popular, and maybe because she's not rude like me, she doesn't misbehave like me in class. She actually, that's a good, maybe Buddha ho gaya na. I don't know how to do that. I don't know how to be nice and friendly. Maybe that's old school. Okay, while you're here and this being Thursday, let me start the class. Before that, let me pay homage to two great teachers. One, of course, my guru, Professor K.S. Anantaraman, who should be mentioned before anybody else. My guru should be mentioned, Professor K.S. Anantaraman. Contemporary with Professor K.S. Anantaraman was another great teacher in Chennai. Who is a great man, who was very popular teacher of cost accounting in the SIRC and, of course, in other bodies also. He was the cost accountant, a chartered accountant. Very, very great man, very strict man, and very, very tough. In fact, I myself, when I was a student, have had a bit of a clash with him. And of course, that was rare. Once early stage. Once I became close to Mr. CAR Shivakumar, I fell at his feet, prostrated, and became a student. And not just a student in terms of costing, because costing was a subject that I could prepare for myself. I loved the subject, and I referred to Horngren and Drury and all that, and I prepared with such authors. Therefore, I got something like, I forget what I got, 79 or something in costing. I don't know. But the point I'm making is that Shivakumar influenced me as a human being. He made me understand what is charity, how to give charity, why our life should be spent parapakarthaya idam shariram. So that is something that R. Shivakumar taught me. So he's a great member of the Institute, of which, the Institute should be proud of such great teachers and members that we had. So he is no more. He passed away last month, untimely death, very young age, but due to illness. So I know this is not possibly a great topic for you to take, but India students, you should know that such a great teacher lived in Chennai, and he taught costing, and was beloved by his students and the teachers around him. And we all mourn his passing. And I take this opportunity on Thursday to pay homage to the great teacher, R. Shivakumar. Thank you, sir, and patiently hearing to what I said. Okay, now jumping into the topic of the day, we have registers. So register is a record. Am I correct? Why do we maintain registers? So that there is a continuous and permanent record. Let me repeat it. A register is a continuous and permanent record. In this sense, the minutes of meetings, they are also registers, because they are a continuous and permanent record of the minutes of the various meetings. Okay. Now, why is it so important that companies should maintain registers and companies should, be punished if they do not? Simple. As you all well know, the company is an artificial person. Now, see, in your case, I'm sure all of us are maintaining journals and diaries. For example, right from almost from 1984, I have diaries, which I've been writing. Even before that, but 1984 onwards, there are proper diaries, which are safely available. A record of my life from starting CA onwards to right up to, today, day before yesterday night. So the point is, it's a continuous and permanent record of what I did with my life. For me, it's relevant. But company is an artificial person. Company cannot, maintain such records. So when suppose Mr. X is the company secretary, Mr. Y is the MD, they go away. Some new people come. Then how will they know what happened? So for continuity and proper recording, there is a need for maintaining registers, right? So these registers are called statutory registers. Why they are called statutory? Because they are prescribed by the law. It is compulsory under the law. Now, in addition to these, there could be other registers also. Not prescribed, but maintained by the company. But these are compulsory. So, the most important of these registers is the register of members, right? So we have the register of members. Before that, I don't know why Nancy says, maybe my Hindi is bad or something, I don't know. The way I said it, Buddha ho gaya na, main Buddha ho gaya na. Sure. What is the? Okay, anyway, I don't know whether my Hindi is wrong. I'm sorry if it's wrong, but I become an old man, no doubt about it. Okay, so anyway, register of members is to be maintained as per Rule 3 in form MGT1. MGT1. Because this is section 88. Remember, one of the earliest sections. What we did, we started in the middle and then we kept moving up. 96 onwards, we started moving up. Right, 100, 111, 112, 115. Then we went, now we are back to 88. So, back to the first of beginning. That's why MGT1. Right? So, MGT1 is the format of the register of members. Also, a register of debenture holders or any other security holder for equity and register of members. For other security holders, like you have debenture holders, creditor, and the creditors are not security holders, preference shareholders, whatever. There should be registers maintained, which will be maintained in form MGT2, right? So basically, we have two registers: register of members and register of debenture holders, and any other security holders. Now, this maintenance of the register of members is prescribed by Rule 5. Okay, and in addition to the register, there should also be an index of names of members. Index. See, in those days there was no computer when the original law in 56, even when it was amended in the 80s and the 85, 88 amendment was there. At that time also there was no computer. In fact, only in 2000, we had proper use of computers. See, between 1995 to 2000 only, proper computerization of shareholder membership register happened. And that again was primitive. And when I say primitive, 100%. See, today we are using advanced, this thing. Oh, okay, sorry, this age is becoming another issue. Sorry, age is a number. I was just saying becoming old. No, I'm not old. Okay, I'm not. Mentally, yeah, physically sometimes just the body becomes old. Emotionally, no. Emotionally, I'm 25 years old. Okay, madam, Sarojji, I'm 25 years old and you are possibly younger to me. So you are what? 23 years old, or maybe 22 years old. Okay. So if I'm 58 and I'm 25, you are 55 and you are 22. Okay. So you have just completed your, college or whatever, and you are ready for CA. Don't worry. You are ready to do CA. You are at the right age for doing CA. Don't worry about it. Okay. In fact, I am planning to do ICAI. I'm not joking. I'm planning to take up cost accounting because that is the only qualification I don't have. See, I'm also a chartered accountant company secretary. All India rank 4 times. So, like an ass, I'm thinking better we write that exam also and see what happens. So I'm thinking seriously. At 6 years, I'll be little more free. So I'm going to start doing cost accounting and write that exam. Okay. So be careful. There's a lot of competition coming. Those of you doing cost accounting, I'm also going to write that exam. Okay. And see what happens. Anyway. Okay. So, see, one more thing. Once, even after becoming chartered accountant, there is no end to the studying. But believe me when I say this. See, for example, today there is something called the insolvency board. For that, if you want to become an insolvency professional or a resolution professional, you have to join them. See, even for chartered accountants, there is an exam. Yeah. I was seeing the syllabus. Luckily, it's company law. So, to an extent, but still, as a student, I'm as much worried as you are. How will I write that lie exam? It's called lie. Don't ask me why. It's called lie. So, seriously, I'm thinking I have to write. So, age is a number. There is nothing called thing. So don't worry, we are going to do it. And age is not a problem at all. Sooner or later, the man or woman who wins is the person who thinks he or she can. Okay. I made this very politically correct so that, because the original poem is sooner or later, the man who wins is the man who thinks he can. But, today politically correct, no, we can't say man. So sooner or later, the person who wins is the person who thinks he or she can. Okay. Fantastic. Let's do this. Let's take this and move on. So the register of members has to be maintained. Index. So when this came, there was no computer. So there will be a members register. The members register will be maintained chronologically. The members register will be maintained chronologically, meaning as and when a person becomes a member, a folio will be added. So which means, for example, Mr. Akbar, for example, Mr. Swaminathan may become the first member. Then about 50 members. Thereafter, Mr. Akbar will become a member. Amar will become later. So A will come later. S will come first. So it will not be in alphabetical order. It will be in chronological order. So the registered folio numbers will be there, but the shareholder name may not be in the alphabetical order. So how to find Swaminathan, or how to find Akbar, how to find Amar, how to find Anthony? So what we have to do, we have to have an index wherein all the A will be one place, B. So against Akbar name, we'll have Akbar's folio number. Against Amar. Then you go to S, against Swaminathan name, you will have S. So if you want to find Mr. Swaminathan's shareholding, you have to go to the index, search for S. May Swaminathan. Believe me, if you are in South India, you will have easily 7 Swaminathans. Okay? And out of that, select one. Yeah, all of them will have initial S. Why? Because their father will be called Subramaniam only. Okay? So believe me, I'm not joking. Okay? So S. Swaminathan will be 7. That out of that S. Swaminathan, based on address, you have to capture this guy and you have to get it. Today, no problem. Today, it's all computerized. You don't have to go by name. You just have to go by the folio number or DPID. Once you give the DPID, the PAN number will be located. Automatically, the link will come and straight away the folio will be displayed in front of you. Okay? So today, it's all numbers. Or you can search, even if you see, you can keep on going. Keep searching for Swaminathan, you're giving all the 7 guys and along with that, the address. Then based on that, you can filter like that. Whatever it is today, with computerization, the index has become a little, shall we say, non-essential. But so similarly, we may be having shareholders who are living abroad, who are citizens of a foreign country, in which case, foreign address. So foreign register also have to be maintained under Rule 7. This is a broad overview. We'll be diving deep and trying to find out what it is and all that. Right. Now, Section 89 talks about the declaration in respect of beneficial interest in any share. See, India is a country where for a long time, since from independence onwards, we had this problem, which we commonly, in common parlance, we call it black money. So how is black money generated? By not paying tax. So if Mr. A doesn't pay tax, where he will keep the untaxed money? He cannot keep it in his own name. No? See, after all, he is taking it out of the business, not paying tax. Somehow he is siphoning it out without paying tax. Whatever it is, that money, again, if he puts it in his name, the government will come and ask him, hey, where did you get this money from, etc., etc. So invariably what happens is this money, or why only untaxed money? There are a lot of corrupt politicians. We have corrupt officers of the government. So they also get a lot of cash, kickback, etc. So where will they keep it? So that will be usually kept in the form of Benami accounts. Benami. Benami means somebody other than me. Okay, I'm keeping it in the name of X, who is not, usually wife, children, daughter-in-law, etc. Which is why you have clubbing provisions in income tax, where income of spouse will be clubbed, income of son will be clubbed, income of son's wife will be clubbed, okay, so on and so forth. So the idea is again that only. See, if you're trying to push your income out of your hands to somebody else, they say, hey, that person's income also will be clubbed with you for the purpose of calculating tax. Okay, and so on and so forth. So the point here is, Benamis are there. So they are saying, hey, if you are not the beneficial owner, If you are a Benami, you have to declare it. Also, the beneficial owner also should declare it. So they're making a statutory duty. In case he doesn't do it later on, in some other investigation, it is discovered that these shares actually the beneficial interest is X. Then X can be punished for not disclosing the beneficial interest. This is one thing. Secondly, you might remember in share capital, we studied that subsidiary cannot hold shares in its own holding company, and also wholly owned subsidiary. Do you remember? Wholly owned subsidiary. So in wholly owned subsidiary, what will happen? Now, suppose the wholly owned subsidiary is a private company. Then the holding company will be holding 100% of the shares of the subsidiary, wholly owned subsidiary. But private company means minimum two members, right? So for the purpose of maintaining the minimum number, the holding company will transfer one share to a nominee who will be holding the share not as his own, but as a nominee of the holding company. So this is again an example where the beneficial interest is with the holding company. Dividend, etc. will go only to the holding company. But the name mentioned in the register for the purpose of maintaining two is the name of the nominee. Nominee will usually be an employee of the holding company or a director of the holding company. He would become the nominee. So this is a legitimate case where the beneficial interest could be held by somebody and the share could be in the name of somebody. This is only one legitimate example I'm able to give. Other than that, this section is meant to be a trap for those people who are using Benami transactions. So the format is given in Rule 9 and MGT 4, MGT 5 and MGT 6. We'll be seeing what this is very shortly. Similarly, they also define another group of people who are able to control the affairs of the company. So they are called significant beneficial owners. About them also we will see. Also, the register of members can be closed for a certain time for updating it. See, this again had relevance in those days, meaning when we were manual days now. So the updating that register, this is like a general ledger now. You have to post it. See what happens now, you will be getting a lot of share transfers. Then literally it's like a posting exercise where you have to go open the registered folio, make an entry. Transfer means you have to reduce it here. Then whoever is the purchaser, you have to go there and add it there. Then tally it, all that. Manually it was done. So it was done on a daily. So the secretarial department, share transfer department will have 3 or 4 clerks with a head clerk who will be reporting to the company secretary. So many people were there. Today, nobody, only one person. And that too only monitoring. Above him, assistant company secretary, above him, company secretary. That's all. Entire department over, secretary department over. If you want to have more people, for the fun of it, you can have. Otherwise, computer is going to take care of much of the grunt work. So, but in those days, we needed to close. So they allowed the company to close the register of members. So they will announce it as book closure. So that any transfer being received after the book closure date now, the transfer will not be registered during the closure of the books. Again, after the books are reopened, after the register of members is reopened, transaction, which means what? Before, suppose the company is going to have an AGM. They've announced the dividend. Now, they will also say book closure. So if before the book closure date, if I do not send my shares for transfer, okay, then I will not get the dividend. So, which is why just before the AGM, when they announce the book closure, there will be that will be about 15 days before the AGM. It will be mentioned in the AGM notice. So, they will rush to think. There will be huge pressure on the deadline date. They have to come. Big job. Which is why, AGM season, the secretarial department will be going mad because they have to update all this. Then they have to ensure that the final list for dividend is prepared so that the minute the AGM is over, the dividend has to be dispatched. And again, physical dividend warrants have to be dispatched. Today, think about it. Nothing. They will announce one date called record date. That's all. The minute you buy the share because it's a dematerialized share, the minute you buy the share, your DPID will be automatically debited. And the other person will be credited or whatever you use, whichever word you want. It will be added in your account and reduced in the other account. Automatically, within 24 hours, the details will go to, within maximum 24 hours or 48 hours, the details will go to the company. And the company's software will capture it. You see what happens now? The company will have a direct leased line, secured leased line connectivity with NSDL and CDSL. If you go to the secretarial department, which I conduct the information systems audit for secretarial department. I'm sort of specialized in that. I can conduct the IS audit of secretarial department. So when you go there, you will find there will be two terminals, which are dedicated terminals with secured leased lines, absolutely secured direct leased lines, not through VPN or not through their local Wi-Fi. I mean, through their local, what shall I say, the router, but it will go directly through a separate leased line to the main router. From where it will go to secured, it will go to NSDL and CDSL. So every day, CDSL and NSDL will send a packet of data, huge file. It will come and sit here through that leased line. Then these people will have an application interface which will take the data from the raw data, and the program will decipher it. And in a matter of 1 hour, all the registers will be updated. All the members, so that next day morning, the registrar members will be up to date. Okay. And there is no question of physical, yeah. You have to come only through online. If any off market is there, that alone will be taken into account by the registrar, which is rare, and close. So that's all. It will be updated almost 48 hours once you will find the data is up to date. Okay. And whenever you want, you can go and inspect it also. You will be seeing that. As a member, you can inspect. So that once they announce the record date, any transaction happening on that record date till midnight will be taken. Beyond that, if a transaction occurs, automatically it will be ignored by the system. Automatically, dividend list will be prepared and all that. We also conduct audit of dividend distribution, where we find out whether the calculation has been done correctly, whether the cutoff date has been monitored, and all that we will see, etc., etc. So the point here is, I'm just giving you all this information so that you will visualize how it actually happens today. See, today all these registers are not manual; they are in system. For almost all listed companies and many large unlisted public companies, which means these registers are relevant only for private companies and small public companies. Small public, not small company. Public company of, say, a certain smaller size will not have. So they will employ a company secretary firm to maintain these registers on contract basis. Okay. And then the share transfer also will be very rare for them. After all, in one whole year, for a private company, there may be no transfer at all. Or maximum, there may be 10, 15 transfers. Maximum. That's it. Okay. So now we move on to register of members. So every company has to maintain the register of members, ROM, in form MGT1. Okay. The holding of each class of equity and preference. So preference shares will not come under security holder. It will come only as a register of members. So for each class of equity and preference shares, you have to maintain separate register, both residing in or outside India separately. For those who are residing outside India, you should maintain a separate register. The entries are to be made in the register within 7 days of the date of approval by the board or committee. Now, so which is another process. In those days, what happens? That share transfer will be in physical form. The IoT form will be there. SHT7, do you remember? SH7. We studied it in share capital. That form will be filled up by the transferor and transferee. The physical certificate will be attached and it will be sent to the company. Company will get it. Then every month, the share transfer committee will meet. Before that committee meeting, what all transfers have been received, they will prepare it. And they will prepare a list and send it to the committee. Then the committee will approve it. Then once the committee approves it, within 7 days, the register of members has to be updated. Again, today, there will be a share transfer committee meeting, but they won't update like that. What they will do, up-to-date transactions will be confirmed to them and said, all these transactions are updated, sir. Because see, today in electronic trading and in online trading, there's no question of you refusing. If you go back to your transfer of shares, public company cannot refuse to register transfer of shares. Straight away, you have no business unless you show that some of the reasons are there. In which case, it will be a bigger issue. They will go to court. Court will pass an order. Then that order will be sent to the DP. Then automatically the DP will flag those shares. So even through online, you cannot sell those shares. Forget, you cannot sell. Forget registering the transfer. You cannot sell it. So such cases, they will just have a naam ke vaste share transfer committee meeting to sort of bless everything and say everything fine, going well, bye. That's all. Okay, they'll get some committee attendance fee and they'll go. That's all. Simply more for the purpose of sort of monitoring rather than action. In those days, it was not like that. If your transfer was not received on certain day, now you will miss one committee meeting. You will take another committee, which means if I send my share for transfer today, I would be lucky if I get it in 1.5 months. It was the type of delays that were happening. I'm not joking. And if anything is wrong, they will reject the transfer. And they will say, this is not tallying, that is not tallying, stamp not affixed, something they will say. And they will reject the transfer. Which means if I'm in a hurry to sell in the market now, I'm gone. So today, thanks to dematerialization, thanks to National Stock Exchange, thanks to online trading, all this is thanks to NSDL and CDSL, nothing. Simple, straight. Okay. Where should the registers be maintained? At the registered office of the company. Just like, accounts, books of account, and minutes, etc. If you want to have it in a place other than the registered office, then you pass a special resolution in the general meeting. For minutes, no need. The board can decide. But for register of members, you have to pass a special resolution in general meeting. Okay, see, this is one case where there's special resolution. So like that, you have to prepare a list of matters which require special resolution. Let us say that I prepare such a list and take that list, I read that list to you in the class, you will go to sleep. It will be a huge list. Okay, so the more exciting activity is you preparing it. That way you will not forget it. If a special resolution is passed in a general meeting in this regard, the register of members may be kept at any other place within the city, town or village in which the registered office is situated, or any other place in India in which more than 1/10 of the total members entered in the register of members reside. So you can say, invariably, I may be wrong, but 95%, 80% of the cases you will find 1/10 of the total members of listed company, any listed company, about 80% of listed companies, more than 1/10 of the total members will be residing in the city of anybody? Any guesses? And I'm just sort of assuming here, but I could be, but then more than 80% of the companies, 1/10 of the total members entered in the register of members will reside in which city? The chances are very high probability that they'll reside in that city. Listed companies, you'll find Mumbai, there will be maximum Mumbai. In fact, 1/10 of the total members. See, majority members residing, I can't tell you. More than 1/10 will be residing in Mumbai, definitely. So you can have it in Mumbai. Nobody can deny, because definitely more than 1/10 will be in Mumbai. I'm not joking, because simple density, boss. Mumbai has got density. People are there. Density coupled with ability. These guys are, they make money, and they definitely. Yeah, it will be nice if I can say Chennai, but I'm definitely not going to say that. Unless the company is, even see, 1/10, yeah, definitely. See, if you count I'm telling 80% of the listed companies, 1/10 of the total members will definitely reside in Mumbai. But whereas there could be a company where, a few companies or 100 companies where more than 50% are in Chennai, no doubt. We have 80% of the companies. Okay? So Bangalore also would be nice to say, but maybe you could make out a list of infotech companies, and then maybe those companies could have, but not all companies. Okay, I don't think so. It will be nice to say Bengaluru, but I'm unable to agree with that. Mumbai, yes, financial capital of the country. So more people are there. Awareness is also there. You see, Mumbaikars are more aware of the stock market because, see, the Dalal Street is just there. Yeah, they know what's happening. And So they will be more thing. Delhi also would be a good thing. Why? For that matter, Ahmedabad or Vadodara should be. I'm sure. But that 80% criteria is where Ahmedabad or Vadodara may not satisfy. But then, Ahmedabad, Vadodara also will have substantial shareholders sitting in Ahmedabad, Vadodara, definitely Bengaluru, Chennai, Mumbai, Delhi. This would be the pockets where you'll have maximum investment in companies, right? Just this is more of a speculative discussion. Don't take it otherwise. So outside of the register office, yeah, you can. See, you can have it either in the same city, town, or village in which the register office is situated, or any other place in India, provided that any other place in India should have more than 1/10 of the total members entered in the register of members. For example, by a different token, let us say that 70% of the members of the company are in Coimbatore. You can have it in Coimbatore. No problem. Your registered office may be in Chennai, but you can have the register of members in Coimbatore. Friends, again, all this works on physical registers. Today, you are having, Hyderabad also included. Agreed. Hyderabad also. The metros, definitely. So now, I don't know if Hyderabad had an exchange. I think they also had a stock exchange. Hyderabad had a stock exchange. Yeah, they did. And so the point here is, so this is all for physical. Today, it's online, boss. You can have a look wherever you are. Okay, but many companies, including listed companies, are not permitting access to the register of members online. Which means, if you as a member want to inspect the register, even if it is maintained in electronic form, you will have to go to the registered office of the company or to that other place where they are maintaining. Okay, so today, see, it's all computerized, etc., etc. Okay, but no company gives access to its members online. Very few may be giving, but not all. So it's not as if you can go to any company and go to their website and say, register of members, then immediately view, then you enter your user ID password, member ka user ID password, then access, I can see. No, you can't. Okay, you can't do that. If you want to inspect, you have to go there. Okay, there should be a reference in the register of members, meaning a noting any order of attachment passed by the competent authority attaching the shares or dividends, particulars of any charge, lien, pledge, or hypothecation of any securities. So this should be there in the register of members maintained by the company, and believe me, it will also be there in the records of the depository when it's all dematerialized now. So anybody wants to buy or sell, suppose these shares are to be sold on which there is a pledge or a lien, then that will be sort of closed, and that they cannot do that, right? In case of a company not having share capital, the register shall contain the following particulars: not having share capital. So here they will simply say date of the member. See, some of this is pure procedure. I would humbly beg your indulgence not to read it fully, but rather to go through a gist of it. Otherwise, it's there in the material. You can go through it, and definitely you will not have to know all this in depth. Broadly, you should know. Okay, that's it. So name, etc., PAN, SIN. Okay, if the member is a company, then SIN. Okay. In case the member is a minor, name of guardian, date of becoming, date of cessation. See, if you really use your logic, now you yourself can design this register. What is the data you will want? When did he cease to be a member? In case any guarantee has been given by him, means being not having the share capital, it could have been a company limited by guarantee. So what is the amount of guarantee? And if in case he is given any other interest, if any, and instructions given by the member with regard to sending of notices, if any. Okay. Now, similarly, every company which issues or allots debentures or any other security should maintain a register of debenture holders, RODH, Form MGT2, right? So same logic. You have to maintain similar register for debenture holders. Similar. Any change occurring in the status of a member or debenture holder or any other security holder, whether due to death, insolvency, change of name, or transfer to Universal Education Fund, etc., should be entered in the respective register explaining the change. See what happens now when dividend is not received. See, when the dividend remains unpaid or unclaimed for 7 years and above, right? You must be aware of it. Right? You studied dividend, right? So when dividend remains unpaid or unclaimed for 7 years or above, what happens? You have to transfer the dividend amount to the Universal Education Protection Fund. Along with that, the share also should be transferred there. That's it. Thereafter, if the person wants to sell the share, whatever, he has to go to the Universal Education Protection Fund, make an application. The IEPF will make an inquiry with the company, get approval, get the confirmation, and then transfer that share back to the company. Then the company will again maintain it and give it to you, and then it will become normal. Then they will inform the DP. Once you give them the DP ID, they will automatically credit the DP, and thereafter you are at liberty to usage. But you have to go through that process. And IEPF usually takes 2 to 3 months. For about 2 or 3 of my clients who are, some of them are very senior people. So when the dematerialization happened, people were simply ignoring it. And so thereafter, share certificates won't come. So the bonus shares will be allotted and kept. So bonus is also not claimed. Dividend is also not claimed. So the complete thing will get transferred to IEPF. One person had in MRF, not joking, check out the per share value of MRF. And then if I tell you that he had 35 shares, you will think, sir, only 35 shares, sir, like that. But don't say only 35 shares. Go and check what is the today's price of MRF. So if you check the price of MRF, you'll be very shocked and surprised. Even 35 shares is a big amount. So this gentleman had not even done anything. He only bought 5 shares, originally 5 shares. And that 5 shares started getting bonus, and then dividend. So dividend also accumulated lying there. So all that. So we help them to, go to the IPF, get it done, then again go to the company, get it done, and all that. So finally they got he was an 85-year-old gentleman. He got the share, and he transferred it to his grandson. And thereafter, unfortunately, he passed away. So, yeah, it is above 1 lakh. Yeah, 1 lakh 50. Last time I saw it was nearing 1.3, it was going to touch 1.5, 1.2 lakh. And that's per share. Per share, one share value. That's because they have not subdivided it. See, still 10 rupees share. So once even if it is subdivided and 10 becomes 10 1 rupee shares, still the price is 12,000 rupees per share, which is at least manageable. Your Maruti Suzuki is now crossed 10,000. It's now crossed 10,000. When I purchased it in 2009, Maruti Udyoga, Maruti Suzuki, or whatever you call it, when I purchased it in 2009, it was the market was damning that company and saying useless, nothing is going to happen like that. It was going at 1,200 rupees. So by the time I bought it, it became 1,500. And it came right down to 900. People are literally saying Maruti will be. I was shocked because I did a simple valuation, intrinsic valuation, very, very simple, even assuming that the market share will go down. I see that at that time when I did this analysis, they were having 52% market share. From 56, they came to 52. I made it 45, which is realistic. Today, they're having 45. So I did 45. I said they will not be able to, they will lose market share. But the logic I went was, yeah, Maruti's market share will come down, no doubt. The pie is becoming bigger and bigger. The jangri is becoming bigger and bigger. So everybody gets a bite in that bigger jangri. So if that so we can understand how the four-wheeler market will grow in India. Enough. So go predict the market and then say, hey, out of that bigger jangri, this fellow will get lower share, assuming. Let's see where he goes. And I found that even with all that, this fellow is getting intrinsic value 3,000 when the market is giving him 1,200. So today the fellow is going at 10,000. So just for your, since we got into per share values, I thought I will make you aware of this. Sorry, that was not required, but I just thought that. Now, as I told you, the index of names have to be maintained, and this index may become meaningless today because it's all online. See, today, when you go to your own contact list, do you go for any index, etc.? You simply type the name of the guy, and automatically then the 3 or 4 names like that will come, and then you will select which one, and that's it for business. So in those days, I don't know if you remember, when I say in those days, I'm talking about before 90 or before 2000. Because even after 95, still people are maintaining phone index. Even now, my father has a telephone index wherein he will, it will be arranged alphabetically, wherein he will write down. So somebody comes, he will write down their name. If their name is, for example, Mr. A. Leo Xavier. So Xavier will go to X. Xavier, Leo, A. So it will become Xavier. Whatever. So when I want to call Xavier again, I have to go X, Xavier, Leo, find out the number, call. In those days, it was like, today what? Yeah, everything is here. Karlo Dunia Mutti mein. Everything is here. Simply you have to take it and do it. So today index has not become, it's not no longer the register and index of beneficial holders, owners, maintained by a depository under section 11 shall be deemed to be corresponding register index for the purpose of this act. So they are saying the DPs, see today with online and with electronic, DPs are maintaining. So that index is the index we are talking about, is what he's saying. And again, the word, you might be a little surprised, said, don't get confused. They are using the word. See, remember, as far as the DP is concerned, the minute they get a transfer in a particular name, they shall be called the beneficial owner only. The beneficial owner, the name of the person mentioned in the transfer shall be deemed to be the beneficial owner only. The DP cannot go around making investigation. It's only the beneficial owner who has to inform the company, right? So what they mean by here is the depositories maintain an index of people who own shares. These are beneficial owners. So I am a beneficial owner of those shares in my name. You are the beneficial owner of the names in your name. You are presumed to be the beneficial owner. But if, in case I am a Benami, it's not my share. It was purchased by somebody else and my name was used for the purpose of holding it. Then I have to inform and he has to inform. Otherwise, what will happen, we will see. So foreign register. See, when the company has issued shares or debentures or any other security in a foreign country, okay, then it can keep in any country outside India a part of the register of members or the debenture holders or of beneficial owners resident in that country. Friends, again, let us be clear. There's an ocean of difference between citizenship and residence. RESIDENCE, residence, citizen. So a person may be a citizen, may not be a resident. Yep. Am I correct? There may be a person who is a citizen of India, but living in US, not coming to India at all. So they are not, they are citizen, but not resident. There they will get green card. Then they will get citizenship of the United States. At which point in time, they have to take the Indian passport and throw it in the dustbin. I'm sorry, what to do? Maybe not throw it in the dustbin, keep it in the puja room and do puja. Whatever you're doing, it is a piece of paper. Thereafter, only the US passport is your passport. India, Mereba, Mara Bharat, Mahan, Jai Shri Ram, nothing. If you're sitting in US, you're sitting in US, you're a citizen of the United States of America. Okay. Whereas citizen of India. But you are a citizen of India, resident abroad. You may be a resident of that country, but a citizen of India. Okay. Now, there are a lot of people, and I'm not joking, today the trend is changing. Many people are coming back and they find India is far better. They find some cities at least, like Bengaluru, for that matter, Hyderabad, Delhi, certain parts like Gurgaon and all, Gurugram, I should say, and Chennai, I don't know. But they feel that It's better to come back and be here rather than in New York or in New Jersey or in Arkansas or whatever that boondocks they live in the US. They feel that Delhi is better. So they say we'll come back. So these guys, they're citizens of US, resident of India. Citizens of US, resident of India. Means they are staying, they've been here for more than 4 years, all that blah, blah, resident and ordinary resident, whatever, blah. But they're still maintaining this US citizenship because it has its own value, whatever, I don't know. So, yeah, citizenship is different, residence is different. Never confuse the same. Okay. So, but in fact, many times, many people get angry with me when I tell like this. They say I'm having, dual citizenship. I said, no way you can have dual citizenship. No country in the world will be foolish to permit its citizen to be a citizen of another country. So this concept of dual citizenship, unless, our Prime Minister's dream should come true, that Vasudhaiva Kutumbakam, Vasudhaiva Kutumbakam, when the whole world becomes one family, when Israel and Palestine should not fight, then maybe we can have dual citizenships, where it doesn't really matter which country I am a citizen of. Because all countries are open, no border, nothing. I can go, no visa, nothing. Like a bird, I can fly wherever I want. If that is so, then dual citizenship may make sense. But only, like, for example, even in India, let us say, you cannot have 2 domiciles. I'm not joking. Try to get 2 ration cards, 2 PAN cards, gone. See, for example, you cannot say, sir, I was born in Mumbai, sir. Now I am fully resident in Delhi. So can I not get one ration card in Mumbai with my old address and one in Delhi? No, you can't. Okay, you can't have both. Maybe you might get away with the ration card, boss, but try to vote in 2 places, you are gone. Okay, it's a criminal offense under the Representation of People Act. Okay, so you have to understand, even within states, it is not possible to have. Okay, within country, how it is possible to have dual citizenship. Okay. Now, it's a bigger point, I just think. So, Anne Mary says she has an index card for recipes. Wow, that's good. Madam, my suggestion, transfer your recipes to your mobile phone, to your OneNote, or to which is what I do. I have a Google Keep, which I upload whatever information I get, so that searching becomes easy for me. So, searching becomes very easy for me. So, if you want eggy bolognese, then you just have to put bolognese there and straight away the recipe will come. Okay. Anyway. Now, the register may be referred to as foreign register. So, resident in that country, you can maintain the company shall within 30 days from the date of opening of any foreign. See, be careful. You might think I wasted your time on this residence issue, but be careful. Just to go back, 1-person company. Citizen of India only can become a shareholder or nominee of a 1-person company. Don't forget that. Not resident of India. Residence does not matter, but citizenship matters. Yeah, Google Doc is better. Sorry, I entered the computer era very, very early. I entered the computer era in 1995. Okay, I started writing programs in COBOL in 1995, and then DBase came, then Foxbase, Fox Pro. Then slowly we moved on to object-oriented programming, and then we came. Then after that, it's all GUI, user interview, and then Java. C, of course, was always there. C++. C was the substratum on which we built everything. So on and so forth. So that way, I am unable to imagine a world without computers. I lived in a world without computers, and I transitioned into a world where I am unable to imagine a world without computers, without my laptop or without my mobile and without my apps and all. I'm unable to think of a world where it is not there. Okay. So, right. The company shall, within 30 days from the date of the opening of any foreign register, file with the ROC notice of the situation of the office in the form number MGT3. Any change in the situation should also be, or discontinuance also, should be informed in MGT3. Foreign register shall be deemed to be part of the company's register of members. Okay, and it should be maintained in the same format as the principal register. Sir, I told you, these are all purely procedural. Okay. Entry shall be made after the board of directors or duly constituted committee approves the allotment. Okay. And if there is no need for it, then they can discontinue the register. The company shall transmit to its registered office in India a copy of every entry in any foreign register within 15 days, which means there should be a duplicate register in the registered office or the place where you are maintaining the register. There should be a duplicate register of every foreign register. And that updation should happen within 15 days after the entry is made in the foreign register. Okay. No transaction with respect to any shares, debentures, or any other security registered in a foreign register shall, during the continuance of such foreign register, be registered in any other register. So that should become the single point for all foreign share transactions. Okay, so not maintaining a register under 88.1 and 88.2. State, not maintaining. Okay. Company 3 lakhs, officer in default 50,000, right? So this is a very good point. To begin with, we had a nice point from our friend Manish Kumar. Very correctly said. See, this penalty, if the company doesn't maintain register, the company has to pay. Then ultimately shareholders become liable. This is something that the government also should think about, and they should bring about personal liability of the director. That is, the company should not become liable for something which only the directors are responsible for, right? So the company's funds, or they should also have a direct reimbursement thing. Even if the company does not make such a condition, where there's a negligence of the director, it should. But see, think about it. In all cases, the director may not be at fault. Are you able to understand? See, it's quite possible that, see, how can I make an entry in the register unless you don't give the details? So in that case, the director is not liable. Nevertheless, the company is liable. Something like that. Okay. But very thought-provoking question, sir. It's made me think a lot. Why should, see, the company is an artificial person. It is the directors who are responsible. Make them pay. Why make the company pay? So very good concept. I don't know. Let me bounce it on some big shots who are authority on company law and say what they have to say about it. I don't know. Seriously. Thank you, Mr. Manishji, for a wonderful thought-provoking. There's no answer for it as of now, but maybe the question is more important than the answer. I'll definitely raise it with all the officials whom I meet in MCA, all the big company secretaries whom I meet. From now on, for 2024, this will be my question. Maybe I'll get a right answer. And if in case we meet again in some other occasion, I'll share that answer with you. If at all they give me the right answer. Or if they say, Mr. Srikanth, that is like this, like that, if they give some standard BS, then okay, chalo, go. Even I get one valid, see, the only man who could have given a valid answer is another great guru of mine. Sorry, today all gurus are coming. This gentleman is also not there anymore. It's a great chartered accountant, company secretary, cost accountant. He went on to become the regional director, I think, and thereafter he went on to become a director in the Department of Company Affairs in those days, before it became the MCA. He is no less than N.R. Sridharan. Mr. N.R. Sridharan, great human being, honest to the core government officer, one of the great persons. His son, Bharat, is a chartered accountant, very brilliant chartered accountant, and NRS was our guru. So I'm giving you names of these are all legends of those days. R. Shivakumar, K.S. Anantharaman, N.R. Sridharan. Okay. I had the good fortune of teaching along with NRS. When NRS was teaching, I was a junior. I started teaching when he was also teaching. So that was my good fortune that I became a teacher. He was my teacher. Then later on, I went on to teach along with him. Good. So he is the only man who could have answered this question. The correct answer he could have given for this. No, he is not there, the answer. Nature of offense. The offense under this section, how we define resident in foreign countries. Hey, Vaishali ji, your question is very interesting. But residence is a very, very loose term. In the sense, it is defined differently in different laws. In Companies Act, it is defined only in one place, that is in where you are talking about remuneration of managing director. Okay, in that place, I think Schedule 9 or something, you will find they talk about, not Schedule 9, some other schedule, I don't know. They talk about remuneration of managing director. There, they talk about residence. There, they give a different definition of residence. Other than that, Companies Act doesn't actually define. In OPC, they give one definition of residence, which is useless because there they say whether he's a resident or not, he can't. So, he only citizen of India can. So, that being the case enough. So, the word residence had to be defined in different laws differently. Income Tax Act has its own different definition. FEMA, we will be seeing. Inshallah, we'll be talking about it. It has its own definition of residence. So instead of asking how to define residence in or how we define resident in foreign country, that's an easy answer. Person resident outside India is one who is not a person resident in India. Non-resident is one who is not a resident. It's simple. If you say he is a resident of your country, then he is automatically a non-resident of your country. Please understand. If you say he is a resident of your country by your rule, then he is a non-resident of your country. If he does not satisfy that condition, he is a non-resident. So each country will have its own preference. In India, we have 182 days. Broadly, that 182 days seems to be some sort of a magic number there. So that is India. So if he is satisfying residence criteria, then he is automatically he is a resident. But if he is not satisfying, automatically he is a non-resident. We don't care whether there may be people who are not resident in any country. Yeah. See, how there is something called the high seas. So they'll be having a yacht or a luxury yacht, where they will be going out and staying in the sea. So to ensure that in no country they will stay more than the requisite time, like that. So there are people like that also. So I don't know about all that. All I know is if your client comes to me, ask him, boss, show me your passport. In India, how many days did you stay? Blah, 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 calculation. Then I will say you are a resident, non-resident. If you are not a resident, automatically you are a non-resident as far as I am concerned. But even though you are a non-resident, in India, we tax him for deeming. So Section 9 is there now. We are deemed to accrue, so we tax him. But other than that, nothing can be taxed in India by us. You will tax him, give okay. Anyway, it's a bigger topic, but I hope I have done some justice to give you my best answer. So the offense under this section is a compoundable offense, meaning you don't, the person who commits it can go to the regional director, fall at his feet, and get a compounding. That means you will pay some extra fees, but conviction will not be there. You won't be found guilty. The proceedings will be dropped. So MGT1 and MG2 should also file details of nomination to be entered in the register of members, register of debenture holders. Meaning, nominee. So idea is, in the event of the death of the shareholder, who will get the shares? Okay, in the event of the death of the shareholder, who will get the shares? See, in those days, nomination was there in the Companies Act. Nowadays, nomination is not there in the Companies Act. Instead, I think it's there in the Depositories Act. I don't know. Whatever it is, once a nomination is there, then a will not work. Suppose Mr. A has nominated somebody, then he dies, and there's a larger will. But to my knowledge, the nomination will be working notwithstanding any testamentary or other documents. What old days know. Now there's a lot of doubt on that. See, for example, if A has nominated somebody and then he dies and he has a will, wherein in the will that fellow says, all my shares in all the companies as on the date of death will be going to my wife and son. Then that nomination, whether it be valid, dispute, keep on going. So then the purpose of a nomination is actually lost. In my humble view, once a nominee is mentioned, then the nominee will get the proceeds or the shares without any let or hindrance. That's how it should be. The nominee need not have to claim, because the intention of the owner of the asset was that in the event of my death, so-and-so should get it. This question was raised to me by a popular magazine in Tamil Nadu, who they used to have a query pad where I was one of the queries, where any question asked, I will give an answer. And this question was asked, I gave my answer, but they had a legal opinion that it is not so. Then thereafter they said, no, sir, we can't do that. I said, "Chalo, no problem. You write whatever you want." Authentication of entries in the entries in the registers maintained under Section 88 and shall be authenticated by the company secretary of the company or by any other person authorized by the board. So authenticated means the register should be sort of signed. Friends, remember one thing. The question is asked by Mr. Prashant Gautam. In exam, we have to write form number also for related section. I'll tell you, one of the greatest advantage of your current paper, as I see it, is about 30 marks are going to be MCQ. 30 marks are going to be MCQ. Now, when I'm trying to look for questions in MCQ, form numbers are easy way out for me. See, I just have to describe the thing and then say, for example, see, simple was, it's very simple. I can set a MCQ. For example, see, register of debenture holder shall be maintained in form number MGD1, MGD2, MGD3, MGD4. So, unless you know the form number, you can't get that 1 mark or 2 marks that we are giving to you. So, if you know the form number, you can simply write it and run away. No, and you'll get, just like that, you'll get 2 marks in your packet, yeah. Okay, so think about it. So that is why, writing or not, knowing, you should. Form numbers, it's better to know. Institute is insisting that you should know. It is necessary. Board of Studies feels that as a chartered accountant, or at least as a person who is going to become an article clerk, you should be aware of the form numbers. Okay, so form numbers are important. Best thing, make a list. Topic wise, make a list. Have a notebook for it. Have a notebook, nice notebook you have. Lot of notebooks are there. I'm sure in the new year, you might have received some gift, somebody or your father or uncle might have got it. You just say, sir, I'm doing CA now. I need notebook. Like, he'll give it to you. Then immediately, why you take it like that? He'll give you prepare neatly form, write, and with your own heart, you write it so that you'll never forget it. Okay. Instead of asking, sir, is it important? You do it. It is important. How you will learn it? Reading again and again, writing it down, writing it down, reading and repeating. You learn it. Okay. I'm just going to skip a little. All this is over. Right? When shares are held in the name of a minor, the name and the details of the minor's guardian shall be entered in the register of members. So here is our friend, Mr. Taneja. Mrs. and Mr. Taneja recently got married. Wow. And jointly purchased the shares of New Hopes India Private Limited on 14th August 2018. New Hopes. Okay. Mr. Taneja intimated the company that only the name of his wife should appear in the records of the company for the shares purchased by them. The secretary of the company is not sure whether this is possible, given that the shares are held in the names of both the persons. See, one day before marriage, Mr. Taneja was saying, "Mere paas maa hai," na? Okay. Now suddenly he has forgotten ma, and now he is only thinking of Mrs. Taneja, and he's saying her name only should appear in the records of the company for the shares purchased by them. No, let us not go into the emotional aspect of this matter. Let us talk about the legal aspect. Is it possible? No. Okay, the answer is, yeah. The answer is, I'm including it here. Of course, this could also have come anywhere else also, but I'm including it here. It could have come, yeah, ideally it should come here only. This question was asked in this topic only. So joint holder of shares may request the company to enter their names in a certain order. For example, if this guy has already surrendered to Mrs. Taneja, no problem. Let her name come first, his name can come second. But he cannot say only her name should appear. How can he say that? Okay. So they can say in the order in which, in a certain order, or execute transfer to have their holding split so that she will have certain number of shares in her own name. With the result that or else transfer the entire thing to her. Yeah. With the result that part of the holding is entered showing the name of one holder and part showing the name of other holder. However, the condition of Mr. Taneja that only the name of his wife should appear in the register cannot be catered to, although the names can be entered in the order in such that the name of his wife appears first. Okay. So the articles of most companies provide that in the case of exclusion of the other joint shareholder, seniority shall be determined by the order in which the names stand in the register of members. So from this question and answer, I learned two things. One, the shareholders can tell how the name should be entered. Once they have done it, all communication will be only with the first named, who will be the senior for this purpose. Seniority is not in age, but in whose name appears first. That person will receive the dividend, will receive all communication, etc. Okay. Now, declaration in respect of beneficial interest. Beneficial interest. I already explained to you what is beneficial interest. Okay. So, see. Okay. He's not started emptying his pockets. He's giving his capital itself to her. Forget income is okay. Capital itself is going there. Sorry, the ladies there mistake me. But again, in all fairness, one wrong view about women that they are not like that. Mrs. Taneja could be a smart lady. In fact, my wife always says that my mother, she was well off and she had a lot of money. She didn't bother because my father was earning well enough. My wife came from a smaller middle class family, love marriage. So when she came in, she saw a household which was, according to her, wasting money. So she started, taking over the money, and she used to save it and all that. And for initially, I found it very difficult to put up with her. But still, the benefit was when I purchased property and all, suddenly from nowhere, she will bring money and give it to me and say, hey, you want 1 lakh, 2 lakhs? Here it is. I've got from my savings, take it like that. So there are both sides to this view. Both viewpoints. It's not just that women waste money. The other way also is possible. So now beneficial interest you have understood now. My name is entered in the register of members, but I have not paid for it. My elder brother, I don't have an elder brother. Just for example, my elder brother paid for it. Okay, or my father paid for it. Instead of holding it in his name, he is putting my name as the owner. So I am not holding beneficial interest in the company. Then I have to inform the company in form number MGT4. I should very clearly state, though the share is in my name, I am not having the beneficial interest. This should be done within 30 days from the date on which my name is entered in the register of members. Right? Similarly, the person holding beneficial interest should inform in form number MGT5 within 30 days after acquiring. Okay. So this is the duty. Right? Any changes in the beneficial interest in the shares should also be informed within 30 days of such change. Okay. Friends, section 89 is there. Nobody will file form number MGT4, MGT5. Believe me. Sir, the whole point of Binami is that nobody should know it is not mine. Yeah. Am I a fool that I will ask him to file form MGT4? I will. Then why at all hold it in his name? Yeah, I will hold it in my name directly. Got it? So this is only meant to act as a warning. The only situation where this MGT4 and MGT5 will be filed, I told you, wholly owned subsidiary, private company, or even a public company, no problem. The parent company, the holding company, will be holding 100% of the shares. There will be only one single member, the parent company. Is still, because it's a public company, they need how many members? 7 enough. So the remaining 6, where they will come from? So the holding company will nominate 6 people, employees or directors, who will receive one share as transfer. But that share doesn't belong to them. They are not holding beneficial interest. So they will file form number MGT4. Also, the person holding beneficial interest is the company now. That company also will file form number MGT5 with the secretary, company secretary of the subsidiary company. Got it? First, they have to inform the company itself. Then, once the company gets this information from them, then the company will consolidate. So, where any declaration has been made to the company shall make a note of such declaration and will file within 30 days from the date of receipt of declaration by it a return in form number MGT6. Okay. Now I am going to let you in on one thing. This topic, 89, important from exam point of view. Why? Because there is an amendment, very silly amendment, not silly, but simple amendment, but that way it's highlighted this area, beneficial interest. So you will find in your institute website, our institute website, that there is some amendments are given. This is the one amendment you will find there about beneficial interest. What that amendment is, I will tell you later. But right now I'm saying, just to remember these form numbers and the concept that I'm telling. Please, huh? Okay, just remember these form numbers, MGT4, MGT5, MGT6. Company to file within 30 days. Okay. Consequence of non-filing, meaning if you don't file, what happens? You'll have to stand on the chair? No. Where a declaration required under section 89 is not filed, then any right with respect to such shares shall not be enforceable by the beneficial owner or by any person claiming through him. So literally, if this declaration is not filed, that's it. The Benami gets it right dryly and runs away. Okay? Because tomorrow you cannot come and say, no, I am the beneficial owner. Okay, you are the beneficial owner. Where is the proof? No, this is the document. See, he has signed and given that he is not. Sorry, did you inform us under section 89? No, sorry. As far as the company is concerned, you are not owner. He is the owner. Go, like that. So this is the consequence of non-filing. Of course, penal liability is also there. Please don't think penalty is not there. This is one of the consequences. Just like there is a consequence of non-registration of charge. Na? There is an addition to the penal liability. Na? Like this is the consequence of non-filing. Okay, so that's it. The legal remedy of that person is lost. See, think about it. Of some of these politicians and some of these corrupt government officials who are taking bribes and investing it in land and building and shares, all in Benami names. They are at the mercy of these people. So long as they are having power, the Benamis will come, or some loyalty. Suppose there is any problem, simply they will take it and go. See, there was a famous cine actor in Tamil Nadu. I will not name him. It's a famous comedy actor who had a very good friend and who was also an actor. A small level actor. These fellows were very close. And this guy used to buy a lot of land and he had a lot. At one time, he was very popular and he had a lot of money. So he used to buy a lot of land. And this guy used to do all the transactions. Because that fellow was busy acting for 365 days. So this guy, all the money he used to handle. And he used to buy the land, etc. In his name also. Again, whatever, avoiding tax, blah, blah, something. One fine morning, that fellow took everything and went away. And that's all. So this can happen. So that is why Benami transactions are always dangerous for the guy. Okay. And there's a separate law which prohibits Benami transactions, right, for information. Very stringent provision. Similarly, you will be seeing prevention of money laundering is there. All that. Very stringent provisions. That's a good joke of Rituraj. Very nicely said. You are telling the thief, hey, please don't break the window, man. Don't break the window. I will open the door for you. So exactly. That is almost like opening the door for the thief. Exactly. Very beautifully said. Not joking. If time permits, I'll tell you one more story, one more nice example given by another great teacher. Okay, later, not now. Once you nearing the completion of topic. Trust which is created to set up a mutual fund or venture capital fund, etc., as may be approved by SEBI. See, think about it. What is a mutual fund? Basically, the mutual fund does not invest its own money or venture capital fund. What it does, it collects money from many people, pools it together and invests it in companies, right? So technically, The mutual fund is a benami. And every unit holder is the beneficial interest. Since the vehicle of a mutual fund is a special vehicle, is a special kind of company, it is exempted. So mutual funds will be holding shares in companies. Now those shares will be held in the name of the mutual fund, though the mutual fund is not the owner of the funds. The funds belong to the investors, unit holders. Still, the mutual fund need not make a declaration, exemption. Okay. Nothing contained in this section shall be deemed to prejudice the obligation of company to pay dividend to its members. Friends, go back to the definition, not now, later, go back to the definition of members, find out what it says. It says, it doesn't say owner of the shares. It doesn't say owner. It says member is a person who applies in writing to become a member and whose name is entered in the register of members or updated in the records of a depository. See, beautifully. So long as that gentleman or lady's name is entered in the register of members, they are the member. As far as company is concerned, they can pay directly dividend to them. Whoever may be the beneficial owner, I don't know. Unless you have made a declaration in MJD4. The central government may by notification exempt any class or classes of persons from complying with the requirements of this section, except subsection 10. That is, it's necessary. They have not done it. So, please note, this is only consequence of non-filing, right? This is penal liability. Any person who fails to make a declaration of beneficial interest, straight away fine, 550,000. In case of a continuing offense, 200. Similarly, the company failing to file the return, penalty 1,000 per day up to 5 lakhs. 1,000, every officer 1,000 per day up to 2 lakhs. In the case of government company, there is no, this provision will not apply. Okay? Section 89 shall not apply, provided the government company has filed its financial statement. So we have seen BO, beneficial owner, or person having beneficial interest. Now we are going to see significant beneficial owners. Significant beneficial owners. Okay. SBO. Significant beneficial owner. See, there may be some people who are owning shares in the company, either by themselves or with relatives, friends, etc. Because by this method, they will be having some control on the company. In order to identify and spotlight them, they say, we want to have a register of significant beneficial owners. So first, then immediately I will stand up and ask the MCA, sir, what is significant beneficial owner, sir, like that. Immediately the MCA is telling, Ayya, the term significant beneficial owner means an individual who, acting alone or together or through one or more persons or trust, possess one or more of the following rights or entitlements in the reporting company. Reporting company means the company which is bound to report about significant beneficial ownership. Such a reporting company, the company which has to make SBO declaration, in that company, one person alone or together, acting alone or together or through one or more persons or trust. So there may be other persons with whom he is acting, through whom he is acting. Or he may be having a trust, and using that trust he may be operating. See, in the US, many conglomerates, many large companies, they will form a trust. And they will form certain entities using the trust. Thereby, for example, the trust will be holding shares. The trust will be basically a benami of the controlling company. But nobody will know because they will route it through 2 or 3 trusts. Finally, one trust will be the owner there and all. And then they'll be doing all things which are anti-competitive, cartelization and all. So in order to punish them, in US, they have these laws known as antitrust laws and all that. Okay? That's why it's called antitrust law. Antitrust law. In the US, the competition law is called antitrust law. So that because they were using trust to, hide the ownership. So what are these? Who is the SBO? He has these rights. Either holds indirectly or together with any direct holdings not less than 10% of the shares. Means indirectly could be through relatives or through others who are nominees or benami. Holds indirectly or together with any direct holdings not less than 10% of the voting rights. Has the right to receive or participate in not less than 10% of the distributable dividend. Has the right to exercise or actually exercises significant influence or control in any manner other than through direct holdings alone. So now it is up to the company to verify. Okay. So what is significant influence? The power, see, they are using the word significant influence or control. So here they say the power to participate directly or indirectly in the financial and operating policy decisions. Majority stake, holding more than one half of the equity shares or holding more than one half of the voting rights. Having the right to receive or participate in more than one half of the distributable dividend. How can you say direct or indirect? When an individual holds any rights or entitlement directly, the said individual shall not be considered as SBO. When an individual holds any rights or entitlement directly in the reporting company, the said individual shall not be considered as SBO because anyway 10% is known. An individual will be considered to hold a right or entitlement directly in the relevant company if the shares in the relevant company representing such right or entitlement are held in the name of the individual. The individual holds or acquires a beneficial interest in the shares of the relevant company under 1892 of the Companies Act 2013 and has made a declaration in this regard to the relevant company. Okay. So either he is the owner or it is being held by somebody, but he has made a declaration under 1892. Then, if once you made a declaration there, here you will not be counted as SBO. You can be ignored, right? In case this will happen where I am holding shares, along with me, relatives are holding, or a company where I'm having some significant influence is holding, or employees are holding, then the suspicion will be that you are holding indirectly. See, this is very, very tricky, my dear friends. Rarely will a company be able to find out. This will happen when, when a group of people are colluding and they are trying to take over a company, mismanage it, and investigation is happening. At that time, this register will become a subject. At that time, the investigating officer will say, call the MD. Sir, now we know for sure that so-and-so is having control over you, sir. Yes, we know for sure that these shares are not belonging to those owners. They have themselves given sworn statement that they belong to X. X is not a shareholder here. Now tell me why his name has not been entered in the register or you have not reported him as an SBO. That is how the question will start. So after all, very clearly, it's clear that he is the significant beneficial owner. Why you have not reported? It's a penal offense. We'll see the penalty later. So then this MD himself will succumb. He himself will be a benami. Then he will start giving further incriminating evidence about the mismanagement. See, we are only beginning with this, but this is not the end of it. That fellow has done more thing. So that also will come. Okay. Now, every reporting company shall give notice in the form BEN4 to any person whom the company knows or has reasonable cause to believe to be a significant beneficial owner of the company, to be having knowledge of the identity of a significant beneficial owner or another person. Okay. To have been a significant beneficial at any time during the 3 years immediately preceding and who is not registered as a significant beneficial owner as required under this section. Okay. So it is the duty of the company to give. See, they use the words very carefully. Knows. Sir, knowledge is one thing where I know. Okay. But here they are saying reasonable cause to believe. Hey, how do I know reasonable cause to believe now? See, I'm sorry to be like this, but this is how I talk. Don't mistake me. I keep seeing Mr. A with a lady regularly in the marketplace. No, I have reasonable cause to believe that she is his wife. That is so reasonable cause. Because, see, regularly I'm seeing you both in the marketplace. You are laughing, smiling. She is hitting you with the banana, but see, she's just taking the banana leaf and hitting you with it. You are smiling. See, assumption is that she is your wife, boss. So I have reasonable cause to believe that she is your wife. That's all I can say. Do I have proof? No. Do I know? No. How do I know? I have reasonable cause to believe. So, in other words, where the circumstances are such that it looks like so and so is a significant beneficial owner, then you have to report it. But think about it, my dear friends. The reality of it is so great. See, this guy, the MD who's running that company, he himself is a chamcha. He is a nominee. He himself is a nominee. How will that fellow do it? You tell me. He will simply, suppose you are the auditor of that company, you go to the MD and say, Mr. MD, I have reasonable cause to believe that so and so is a significant owner in your company. Is it right or not? He will simply smile at me and say, I'm not aware of anything like that, sir. Like that, he will say. Then you tell him, I have reasonable cause to believe that these shares are not owned by the beneficial owner is Mr. X. He will simply smile at you and say, sir, I'm not aware of that. Sir, if you have any proof, kindly proceed with your audit. Like that, he will then smile and go, because he will then go back, after you leave the office, he will call that man and say, sir, this fellow is creating, this auditor is creating so much trouble. Where did you get this fellow from? Oh, is it so? I will take necessary action. So that fellow will call. Again, he will do all the necessary things. Next meeting, sorry, sir, we are auditors, we are changing. We are very sorry, like that. So now you relate this to removal of auditor. If the directors want to do that, this is where the problem will start. So immediately the matter will have to go to tribunal. The board of directors cannot remove the auditor. The matter will go to the tribunal. It will become a big thing. You are the auditor. Now you will be able to go there. And there you will tell, I have reasonable cause to believe. I have inquired. They are not giving a proper reply. The matter will be there. In the meantime, the press will catch it. And that's it. The MCA will come in, the investigation will start, everything will start. Okay? So, at that time, all this will become relevant. In the normal course, a normally run company, a well-managed company may never have to have been for all that, all these forms and all, nothing. If you are a normally well-managed company, in your life, you will not know what is MGT4, MGT5. If your company secretary says, I'm having extremely good experience in section 8990, then I'll be worried about him, because this fellow is only working with companies where benamis are there. What type of fellow he is? Like that I will ask. Okay. Every company shall maintain a register of significant beneficial owners in form number BEN 3, which shall be open for inspection, etc., reasonable time for not less than 2 hours every working day, etc., etc. The same thing. There's nothing greater. So, okay, you go. Next time you buy a share in some company, then go to that company and you talk to the company secretary, say, sir, I want to see a register of significant beneficial owners, sir. As part of my CA curriculum, I have studied it. And I want to see this form number, BEN 3, sir. Can you please show me? You look at you as if you are an alien landed from some planet. And you say, what, BEN 3? What BEN 3? Then only you start referring, because nobody will know, yaar. Seriously, I'm telling you, nobody, because this will happen rarely, BEN 3 and all. But suppose there are significant beneficial owners, then believe me, so you have selected one rare company where there is a BEN 3. Okay? Check it out. Of course, one rare exception one normal exception I've given you, where wholly owned subsidiary and it's holding company. There, you will have beneficial ownership now. But even there, you will not have SBO. There is no question of SBO. No SBO. Okay. So, in case a person does not give the company the information required by the notice in form number BEN 4 within 30 days. See, now think about, go back to my situation. I am the auditor. I am telling you as the MD, board of directors, I have reasonable cause to believe that so and so is possibly a significant beneficial owner. Now you go to that gentleman and say, hey, please give me the information for filing in form number 24. He says, go to hell. What can you do? Then, where the information he is giving is not satisfactory, or he fails to give, then you can apply to the tribunal, period of 15 days, for an order directing that the shares in question be subject to restrictions with regard to transfer, suspension of the right to receive dividend, etc., etc. Okay. So this is possible. Friends, all this will happen when there is a dispute between two groups. Then all this will be done. Everything will be done. Anything will be done. Then the tribunal will give an opportunity of being heard and then may pass an order restricting the rights on those shares. Okay. In case any person is aggrieved, then they may make an application to the tribunal for relaxation within a period of 1 year from the date. If no such application has been filed, then the shares shall be transferred without any restrictions. Okay. 1 year, they will be locked. So every individual who is an SBO in the reporting company shall file a declaration with the reporting company in Form Ben 1 within 90 days of such commencement. Then the reporting company will require to file the said disclosure within 30 days. Okay. So, correct. They could have made it pen 10. It's a good one. Any individual who subsequently becomes a SBO in the reporting company or who has undergone any change should file a declaration within 30 days of such acquisition. So this is a corollary, right? Follows. If the person becomes a significant beneficial owner or they undergo any change within 90 days of the commencement of these rules, it shall be deemed that such individual became the significant beneficial owner or any change therein happened on the date of expiry of 90 days from the date of commencement. That is, when this law came now, immediately they could not, handle it. So they wanted some time. So they said, chalo, I will give you 90 days. And if any change is happening within 90 days of the commencement of this, then after the expiry of 90 days, you take. And then the period of 30 days will be reckoned. So they got 90 days time. But after they said, if within 90 days anything happens, immediately you don't file. Wait, then collect all that, and then after that, within 30 days, you file. So it is like a grace period. See, because when the law came, they immediately said, all SBO within 30 days you have to file. Now they say, hey, sir, we don't even understand what it is. Give me some time to understand. Chalo, 90 days. If after 90 days, your period will start. Then within 30 days, you file. So in case the SBO fails to declare, initial failure 50,000, thereafter not filing, continuous failure 1,000 day. As quickly, see, okay, you failed 50,000, immediately come and file it. Still not filed, then 1,000 day, 1,000 per day, restricted to rupees 2 lakhs. Right? In case the company is making the contravention, then company for initial failure 1 lakh, continuous failure 500 per day up to 5 lakhs. Officer, initial failure 25,000, continuous failure 200 per day up to 1 lakh. Right? Now, so there is also a register of SBOs to be maintained, etc. What I will do is, at this point in time, let us have a small break for 5 to 10 minutes max. Right? So, small break. Thereafter, we'll again take it up. Inshallah, we'll finish this topic today. In case I have some time at the end, please keep any queries you have with you. I will try to take it up if you have. If I have some 10 minutes gap at the end, let me see. Okay, as of now, let us go for a break. Sir, break, sir. from your well-deserved break. Let's see if you have any questions to ask me. No, I don't see any more questions being raised in the query pad. So let's presume that there are no. Okay, we have Mr. Manav Agarwal, whom I definitely remember from the last batch. He got 60 in law, number 23. And he says, he thanks. So many students do this, when the results come, and if the current intermediate online classes are going on, they actually log on and they put this message. It's very nice to know that people have cleared. Okay, I'm so happy for Mr. Manav and wishing him all the very best. And if he is going to go for the final exam, we will wish him all the best for that also. Great. And especially I'm very happy to hear 60s. Almost everybody who thanked me or who sent a message has got 60 plus, because that is the thing. Onus means burden. Where did you find the onus? The word onus, O-N-U-S, onus means burden or duty. So we usually say the onus of proving something means the burden or duty of proving something. Onus is burden, duty. Onerous means burdensome, difficult. So you can say onerous responsibility means O-N-E-R-O-U-S, onerous responsibility, difficult, tough. Yeah, beneficial owner is that who are beneficial. That is beneficial. No, then you are, see, what is beneficial interest? See, if anything happens to those shares, who will be affected? That is the beneficial owner. Okay, who will be affected if anything happens to that share? He is the beneficial owner. Okay, see, suppose a building is being held by a Benami on behalf of somebody else, his name is entered as the owner of the building. One day there's a flood and some problem and cyclone, and that entire building is collapsed. Who will be worried? The Benami will be bothered. What is there? It's not mine. My name is there, so what? Whereas the real owner will be there. He will be like that. What to do? Is insurance. They call this Benami. Hey, go and file insurance, man. Okay, sir, I will go like that. So who will be affected if there is a problem? That person is the beneficial owner. Who will get the benefit also? Beneficial owner. See, that way, if you really look at it, no, we are all Benamis. Yeah, all of us are Benamis. Who is the real beneficial owner? Bhagavan. There's only one beneficial owner. We are all Benamis. He is sitting in all of us and running us. We are Benamis. Once you accept that you are a Benami and live life like a Benami, no worries, nothing. Everything will be going on. Because Bhagavan is the owner. I'm not the owner. So, register of significant beneficial owners in a company. Contravention by company and officer in default of provisions of section 90 and SBO rules is compoundable. We have already seen that. Okay. Where SBO or officer in default intentionally furnishes any false or incorrect information, then they will be liable for fraud under section 447. I hope you remember the 10 lakhs, 7 years, all that stuff. Of course, government company is exempted and etc. Provided it has filed its financial statement annual returns. All that is the same, blah, blah. Now, we have seen beneficial owner and all. There is one thing that you might want to, I will want to, sort of take it up. Just give me a permission to do this. See, if you go to your institute website, therein you will find that there is a amendment is there. So there they have given the amendment. I'm including it now. I'm just showing you that sheet now. Maybe I will even make it a little bigger if I can. Yes, I can. Okay. So, Chapter 7, Management Accounting, there was one amendment in 27th October 2023. Okay. It's a very small amendment in Rule 9, which is pertaining to beneficial owner. Okay. So, every company shall designate a person who shall be responsible for furnishing and extending cooperation for providing information to the registrar or any other authorized officer with respect to beneficial interest in shares of the company. See, what could have happened? They might have gone for investigation where they would have said, I don't know, you don't know, who is responsible? Nobody is responsible like that. Everybody would have appointed everybody else. And what would happen is at the time when they go, there will be no company secretary. There would have been a company secretary who would not be reachable. So the MD will say, sir, all that was entrusted to the company secretary, sir. Now he is not. Now that company secretary is not there. Then this guy who's sitting here, sir, I'm a new man, sir. I don't know what happened. Something they will say. So in order to clarify, they said, look here, every company shall designate a person who shall be responsible for furnishing and extending cooperation for providing information to the registrar. See how pathetically, extending cooperation, okay, for providing information to the registrar or any other authorized officer with respect to beneficial interest. So, for that purpose, the company may designate the company secretary, key managerial personnel other than CS, because CS is also a KMP. Every director, or if there is no company secretary or KMP, if there is company secretary, straight away company secretary. Okay, and KMP, other than the company secretary. Where there is no company secretary, all directors or KMPs will come, every director again. Until a person is designated, okay, then the following person shall be deemed to have been designated person. Company secretary and managing director or manager, etc. Every director, if there is no company secretary or anything. Okay. So this is just for information. Every company shall inform the details of the designated person in the annual return. And if there is any change in the designated person, you should inform the same in GNL 2, general. GNL is general 2, specified under the company's registration offices and fees rules. Okay. So this is just for your information. So you can make a correction in page number 7.13 of your material and proceed. I have not specifically mentioned rule numbers because it's too much, okay, remembering rule numbers. But section numbers, try to remember. Form numbers, very, very important. Please don't ask me again about it. Form numbers are important. Make a list of form. Was if you don't want to prepare it, you still want a list. It is there in Google, Baba. But my humble request, keep that Google list. Prepare your own list and check it out. You will never forget the form numbers. Okay, now we move on to closing of register of members. I told you now. So the register of members or debenture holders can be closed by giving minimum 7 days notice. Okay. I explained to you why it will be closed in order to finalize the transfer and all to determine who will be eligible for dividend. So in those days, they will be announcing a date. Any member whose name is there on that date will get. Even now we have something called record date. Now, so the company has to update its register now. So it is like this, as in Tamil Nadu, we have this proverb, but I don't know if you do have it in Punjab and Haryana and Kerala or Gujarat. See, the proverb is like this. It says, you can't take a bath so long as the waves are there. So if you say, unless the waves stop, I will not take a bath. You can never take a bath. Because in the sea, waves will be coming continuously. If you say only after the waves have stopped, I will take a bath, you can never take a bath. So whatever may be the wave you get in like that, that is the essence of this proverb is, don't wait for the right moment and all, it will never come. Go ahead and do what you want to do. That's what it means. Having said that, in the case of a company, transfers will be happening every day, continuously. So how to do it? So there the law says, hey, you stop it. So you tell them, on such and such a day, I'm going to close the register. So any transfer received after that date will not be entered immediately. Only after the register is opened again, we will make entry. So those transfers which are received up to that cutoff date will be updated and only they will be entitled to dividend. So this is the logic of closing. In those days, when physical certificates were there, manual entries were made. Today, as I told you, online trading, direct updation. Therefore, for listed companies, they will never close the register for no reason at all. But unlisted companies, yes, having many shareholders and transfers may. But most probably, unlisted public companies, the transfer shares will be very less. But still, they might want to, for sake of propriety, they might say the register of members shall be remain closed from so and so date to so and so date. So, how long can I keep the register closed? You can keep it closed for 45 days in 1 year, but not exceeding 30 days at any one time. Okay. Even those cases where they used to close in those days, they will not close beyond 15 days. So just before the AGM, they'll close it. On the date of AGM, they'll open it again. And all the shares received as on the midnight of the opening day, that will be updated. So that on the AGM date, only those names will be there, they will get rid. Okay. So this is what normally people will do. This is called closure of register of members. Today, with electronic trading, with computerization, there is no need for closure. If beneficial owner, very, very tricky question. If beneficial owner ceases, means who like that dies, then who will get benefited? I don't know. See, think about it. If the beneficial owner has already declared it, that they are the beneficial owner, then the legal asset thing. But if the beneficial owner has not declared it, then Benami only will get it. The guy whose name was entered there, he will only get it. So that is the problem. So if you say, see, that's what I'm saying. No, the father will invest through Benamis. Then one fine morning, without telling anything, he will die. Then this guy will find a diary in that this father would have beautifully written all the list of assets I am having in the name of donkey, monkey, like that. Then he goes to donkey and says, hey, donkey, my father has written the diary that these shares belong to him. The donkey will simply say, what share? Whose father? I don't know anything. Go. Nothing can be done. Nothing can be done. If at all the beneficial ownership has been declared to the company, then you can claim. Okay. So this is the answer I'm able to give you, Mr. Prashant. Practically, I can only give you this. Which is why, what use of money which cannot be owned or which cannot be enjoyed in our own name? What is the use of that money? Think from an ethical perspective also. What is the use of money which is not in your hands? You see, they say, parahasta gatam dhanam. Parahasta gatam dhanam. Money that has gone to the hands of other people. What is use of it? It cannot be used when you need it. Okay? That knowledge which is only in the books, that money which has gone to the hands of other people, it can never be of use to you when you need it. Okay? So, there is no point in giving our money to somebody. Parahasta gatam dhanam. Why? Okay? And knowledge which is only there in the books and not in our brain and will not be available at the time of need. Okay? So, sorry, I just kept pushing. So, we've seen this. If the registers are closed without giving notice, shorter notice, etc., there will be a punishment. Company and every officer, 5,000 per day. Okay? Offense is compoundable under section 441, not in your syllabus. Not in your syllabus. Private companies have been exempted from issuing public notice in newspapers, provided it issues 7 days notice to its members before effecting closure. Rarely I've seen a private company closing the register of members. Okay. Now we come to another very important section, 92. Just like the annual general meeting is a regular feature, financial statement approval is a regular feature. Similarly, filing annual return is an annual feature. Every company shall file its annual return in form number MGT 7. This is another favorite form of the company secretaries. MGT 14 divided by 2, MGT 7. They allow it because every year they have to certify it. The MGT 7 in those days needed to be certified by a company secretary. So every company, so they used to get some fees on it. So the MGT 7, they allowed it. Every company shall file its annual return in form number MGT 7, except OPC and small company. So when the small company thing came, straight away MGT 7 gone. For them, no MGT 7. Small company. 1-person company and small company shall file an annual return from the financial year 2021 onwards in form number MGT 7A. Slightly less complicated form. Okay. So they should prepare a return. Okay. As to referred to as the annual return in the prescribed form. It will contain details regarding registered office, principal business activities, particulars of holding and subsidiary and associate, shares, debentures and other securities, and shareholding pattern. Very important. Shareholding pattern. See, I'll tell you why. Suppose you want to know something about a company, basics. The best thing for you to do is to download this annual return and see it, which will give you a broad idea as to, as on the date of AGM, what was the position? Last AGM, you will get one shot, one capture, you will get picture, you will get something about that company. Its members and debenture holders, along with changes completely. Its promoters, directors, key managerial personnel, along with changes therein since the close of the previous financial year. Everything will be there so that you will know for sure, hey, this guy was newly joined, this guy is newly joined, that guy has left. All that will be there. Meetings of members, how many times it happened, board and committee meetings, how many times, who attended, all will be there. Remuneration of directors and key managerial personnel. See, this is a public document and is available to you and me to go and see. So there's a lot of transparency to corporate activities now because of this. Everybody knows what's happening. Penalty or punishment imposed on the company, etc. If there's anything. Matters relating to certification of compliances, disclosures, anything. So auditor is qualified, it has to come here. Details as may be prescribed in respect of shares held by or on behalf of the foreign institutional investors, such other matters, wherever they are prescribed, it has to come. Annual return is a very, very important and interesting, document, right? Annual return has to be signed by a director of the company and the company secretary. In case there is no company secretary, by a company secretary in practice. For one-person company and small company, the annual report shall be signed by the company secretary or where there's a director. See, in those days, the certification of companies now became very important. That is certificate of annual return. So the certification of annual return was very, very important. So where the company has a company secretary, he will sign. But where there is no company secretary, that annual return had to be certified by a company secretary in practice. So this was a nice income for them. Then when the small company limit was increased, now many companies which entered of the good list. And now very few companies are there in that list. So they will have to certify that. Okay. For OPC and small company, the annual return only by the company secretary. Where there is no company secretary, director can sign. But even then, see, usually the link is like this. I am the auditor now. First mind, I'll be there. So the minute they come, when I form a company, I'll tell them, boss, this is a company, lot of complaints are there. I am only chartered accountant. I am not the authority on company law, though I am. But better you go to a company secretary who's supposed to be the authority on company law. Go to him. He will tell you everything. Like that. At that time itself, I'll send him. We have a panel of company secretaries. We'll give that list and we'll say, any one of these people go, find out who is the best for you, based on rate, based on, all are recommended, all are good. But go to the man whom you think budget is there, then go to somebody budgeted. Otherwise, if the budget is not there, slightly large government, you go to X, you go Y. It's your choice, go like that. Okay. So, whatever it is, I have verified them. They are all equally good and efficient. Kindly go. So, we will be the first point of referral for the company secretary. So, we will tell them, you have to get it certified, sir. Better go there. The client also will get angry. Already one fellow, you are there wasting my time. You want one more person, Mr. Srikanth. Why don't you do it yourself? No, sir, I can't do it. Though I am a company secretary by qualification, I am a chartered accountant by practice. So kindly go to that other gentleman or lady as the case may be and get it done like that. So it's like a cardiologist, referring to a nephrologist. I have to send him to somebody else. I'm not the authority on that. Go there. I'm only diabetologist with cardio. He has to see in a kidney, I can't see, go there. The liver, I can't see, go there. So like that, everybody will take a pie and take a cut of the pie. Okay. The central government may prescribe abridged form of annual return for one-person company, small company, etc. Okay. The smaller version. The annual return filed by a listed company or a company having paid up share capital of 10 crore or turnover of 15 crore shall be certified by a company secretary in practice. Signing annual return is one thing. Please understand. Signing. Whereas here it is certifying. So it's like an audit. Just like we do an audit of the financials, the company secretary will audit the secretarial and compliance of the company under the Companies Act, etc. And then he will certify the annual return. Okay, so that certificate has to be given, but only for those companies which are listed or where they have a paid up share capital of 10 crore or more, turnover of 50 crore or more, should be certified by a company secretary in practice in form number MGT 8. It must state the annual return, that the annual return discloses the facts correctly and adequately. Okay, so that annual return should be placed on the website. A copy of this is very, very important. Please remember, financial statements should be filed within 30 days. Annual return shall be filed within 60 days from the date of AGM. Do you remember financial statement? Do you remember? That was 30 days from the date of AGM or the date on which the AGM ought to have been held. This should be filed within 60 days. Where no AGM is held in any year within 60 days from the date on which the AGM should have been held, along with the reasons for not holding the AGM. Do you remember? Link it with that. Okay. Failure by company to file annual return, fine, 10,000. Continuous failure, 100 up to 2 lakhs. Officer, 100 per day up to 50,000. The company secretary in practice, in case, there is some wrong certification and all, then that should be up to 2 lakhs, fine. Okay. Failure by company to file annual return before the expiry and certification by company secretary otherwise than in accordance with this section and the rules. So the company secretary should ensure that everything is in accordance. The registers and returns should be kept in the registered office or else can be kept. See, here we are not talking only about members register. All registers and returns. There are so many registers. See, there is a register of shares held otherwise than in the name of the company. For example, when you are the holding company and your shares are being held in the wholly owned subsidiary, some portion will be transferred to that nominees. To that extent, they are not held in your name. So for that, there is a register prescribed. Beginning with that register, right up to register of investments and intercorporate investments. So there are so many registers and returns. That itself is a separate list of registers and returns, including minutes. Everything is registered. And all the returns that you file, everything should be kept preserved in the registered office. Or you can keep it in a place in India other than registered office where more than 1/10 of the total members reside, if approved by a special resolution. So the registers, etc., should be open for inspection by any member or debenture holder. Okay. And by any other person on payment of such fee as may be specified. Any member or debenture holder or security holder or beneficial owner can take the extracts during any business hours without payment of any fee. But one small word of caution, the registers that we have seen up to now are available for inspection by any other person. But there are some registers which are not so available. There are some registers which are not so available. Similarly, MGT 14, available for inspection, except board meetings, which the 179(3) matters, not available for inspection. Okay. By other than members. Other than members cannot see. Preservation of register of members. The register of members should be preserved permanently. Permanent. There is no 10 years or 8 years or no. And shall be kept in the custody of the company, the company secretary, the company or any other person authorized by the board. Similarly, so the register of members, the register of debenture holders shall be preserved for a period of 8 years from the date of redemption of the debentures, not from the date of issue, from the date of redemption of the debentures, and shall be kept in the custody of the company secretary, etc. All copies filed with the ROC should be kept. annual returns and all certificates, documents for 8 years from the date of filing with the ROC. Foreign register permanently, unless it is discontinued. Okay. Foreign register of debenture holder, 8 years. Okay. In case any inspection of the register is refused, then there's a penalty of 1,000 for every day, up to 1 lakh. Central government can also order the immediate inspection of the documents, right? Registers, etc., shall be prima facie evidence of any matter director or authorized to be inserted therein by or under this act. So once it is shown that it is there in the register, see, registers are very powerful documents. I have got certain cases where I use certain registers which we maintain, not statutory, voluntarily maintained registers, if properly maintained, become record and evidence to show that payment was made. Okay, like that. We have a Tapal register, outgoing Tapal register. So whenever a Tapal goes out, post goes out, it is entered there. Similarly, inward. It's a very, very old British system that I still continue. Though, of course, in today, hardly in 1 year, there'll be 15 entries or 20 entries. But still, I religiously do it. When I send a courier out, it gets entered there. It became a very great evidence for me in a case where one person accused me of not doing something. I said, look here, see the register, it is there. And I also had luckily a scanned image of the document. Then the question came, yes, you signed the document, etc., but did you send it? For that, I had the proof. I showed my Tapal register wherein sequentially 3 couriers have gone to the same person, to the same authority. And I said, look here, this is this. Proof is there. So the evidence is so strong. Hey, definitely he has sent a courier on that day. 3 couriers have gone. Definitely this has come. Like that. So once you get into court now, the evidence and all becomes very difficult to argue. As I told you, I said I will be having some time today, which is what has happened. So in case you have any doubts pertaining to this topic or an earlier topic, etc. So, which company means private or public, boss? Suddenly, if you ask me out of the blue, how I can answer? All companies. This section applies to all companies. Private, public, etc. Nowadays, there's no big difference between private and public. No big exemptions for private companies. So I'm happy to say that this topic could be completed. I was thinking we may not be big itself. So we have completed it. Kindly, as I told you, this beneficial owner thing now, 89. Just go through it once. Just like that, go through it. But also significant beneficial owner and all. So that suddenly if you find its ugly face in the exam, you will not be frightened. Okay. Okay. So if you have no more questions, I will give you 5 minutes to ask. If within 5 minutes I get no more questions, I shall presume that you have no further questions. This session, inshallah, we'll meet again. At which point in time, if you can further raise whenever you want, you can raise. If you have any other queries after the classes are over, you are not asked, then send it to the Board of Studies. Board of Studies always having a lot of the dedicated people who will definitely try to answer your question. And also they will consult faculty like me, who will be also giving the inputs. Finally, you will get a very good answer for your query. Okay. So kindly ask them. Also, in case you have doubt on exam, how to write answers, how to present and all, the horse's mouth is there. Na? That is the Board of Studies. Na? So one of the classes, I'm told, one class I may have to go a little early, so that half an hour, one of the very, very senior person from the Board of Studies, one of the faculty, she will be there to help you. They will be there to help you to answer your queries on how to write the exam. And all you're asking now how to write, how to present. The horse's mouth will be there. Srikanth is only guessing because he's also, like you, an outsider. So the horse's mouth, you'll get it from the Board of Studies itself. So please do attend that class. As I'm completing it, they will inform you and I will inform you and I will go away and they will come and they will take. Thank you and wishing all of you a great, whatever, Vaisakhi, Madhura Shankranti, Pongal, whatever you call it. Yeah, all the provisions relating to public company apply to a deemed public company also. A private company which is deemed to become a public company, it will apply. Except where the Act very specifically says no. 1 or 2 cases it says no. Okay, good. Thank you. Bye. And wishing you all the best. Sir, dividend chapter, there is no time today to cover, but I will take some revision, please. 100% I'll do it. I wanted to do it today, but today again, this time is not sufficient for dividend. So just please wait and do it. But definitely I'll do one thing, Ma. I will upload the dividend notes onto the portal tomorrow. So just go through it once. If you still have a doubt, you ask me a doubt, I'll answer it, definitely. Maybe a little revision I'll. Okay. Next class, Kane Hugi. Yeah. Next class, I think, I don't know what. I'll be talking to you on 23rd. I was told. Okay. Bye. So class over, sir. Sir, class over, sir.